Hi, hello. How are you doing? Welcome to Lawyers Info Hub. It's always a pleasure to have you on this platform. Yeah, this platform is born out of passion to support the growth of legal education in Nigeria and Africa. You see, we are doing all we can to simplify legal knowledge so that you can get it as easy as possible. You can have it at the tips of your fingers. You know, uh, we want law students to be more equipped, we want young lawyers, even older lawyers to also refresh their memory, to also understand and also keep tab with legal knowledge because you can't have it enough. And the more you have it, the more you understand it, and the more it makes more sense to you. So today we're looking at the still looking on cross examination, but now we are looking at the what you could call it the rules, you could call it the commandments, you can call it the um, I can call it the ABC of cross examination, whatever you want to call it, but we're aimed at helping you understand it. What are those things you must know at the back of or the palm of your finger during cross examination to guide you, to do it well and get the desired result is very important and get the desired result. So the first thing you must understand in cross examination is that you must be brief and ask short questions. When your questions are longer, it's very difficult for the witness to even comprehend it and give you the desired what result or the desired answer you would anticipate. So you have to be brief and your questions were short. Be brief and let your questions be short. Another very important thing you must understand is that let your language be simple. Don't be verbose in asking your questions. Let the witness even understand what you are asking. Be simple in your language. Avoid verbosity. Avoid too much of grammar, or avoid trying to show the witness you can speak English. So keep it simple. Let your language be simple. Be brief. Ask short questions. Do not ask questions that you do not know the answer. For example, you're trying to cross-examine an expert witness. You're trying to cross-examine someone in the medical field, and you do not know those details. It's very tricky for you to ask those answers when you don't know the question, those questions when you don't know the answer, because the witness might confuse you. So, for every question you want to ask someone in the medical field, try and get the answer. Seek knowledge, seek opinions of others, read, understand what those terms are, what it means. Then when you're asking it to the person, you already have an expectation. When you're not meeting the expectation, if you're able to say, okay, this is not this, this is this. Because if you don't know the answer, whatever the witness tells you, you might just believe it, just like that it is the right question or the right answer. So the rules of cross examination expect you to be brief, you know, ask short questions, let your language be simple, avoid verbosity, avoid those grammatical things you want to do to showcase to the witness that you are a lawyer. Avoid them. Let your language be simple, because when you keep using big words on the witness may not be able to even understand what you're saying. Do not ask what non-leading questions. Ask leading questions that will help propel answers your desire. Ask what Do not ask non-leading questions. Very key. So because when you don't ask non-leading questions, it's very difficult for your witness to even get get straight to the questions or the answer to desire. But when you ask leading questions, the answers are just, you're guessing it. If it's a no, you can know. If it's a yes, it's a yes. Active. You let it be active. Do not ask questions that you do not know the answers. Another very thing most many lawyers do during course examination, they don't even listen. They only ask. You don't want to listen. Listen to the witness when they respond, because from their answers, you might have a need to cross further, ask for other questions that might come out from those answers. So you must pay attention, listen. And why many lawyers don't listen? I've tried to wrap my mind around why lawyers don't listen when they ask this question. Is that most of them are also the ones recording. when you're going on trial, try and have someone to record for you. And also you don't just push people to record for you when you already called your matter. You just see someone beside you, please record for me. No, it has to be a pre-arranged discussion with either the counsel beside you or even your junior or your colleague or your friend. Say, please, I'm going for trial today and I am going to ask questions. I'm going to cross-examine. I need someone to help me record, because if you're recording, it will be difficult for you to even listen to comprehend the answers the witness is what giving, because you're bent at even writing what the witness is saying. So you may not be able to even get the grasp or interject or interpret or even digest the answers the witness is what giving. So another thing is that do not quarrel with your witness. You see, the mindset of a witness and a witness boss can be very corrosive. Like the mindset where I'm not going to allow this lawyer intimidate you, and you have the mindset of I'm not going to allow this witness intimidate me. You begin to clash. As much as you want to be forceful, as much as you want to achieve, want to be in charge, or you can do that in the most cautious way. Don't quarrel with your witness. When you quarrel with your witness, you may end up not getting anything. You're not eliciting anything. The witness will keep becoming, saying things that you don't need. And if the court is one that will just relax and be looking at you, you may end up not getting anything you want. End up not getting anything you want. So you must know how not to, calm the knives. I've seen, cross-examination questions like, going on smoothly, peacefully, and the client, the witness is just dishing out answers. And then also when we're very cantankerous. When it's cantankerous, the atmosphere is tense, the witness is angry, you're not gonna get the right answers you want. Now, it's also very important that you never commit or your witness to explain or repeat the story. Very important. Do not allow your witness to repeat the story. Very important. Don't give room for that witness to repeat the story. You don't need that story. Ask your questions and get answers. That's what you're there for. And another thing is that you have to take it easy. Ask the questions one at a time, not as the witness is trying to answer, you're asking another one. Is it true? I put it to you. The witness isn't trying to digest the one you just asked, you're pouring out another one. So you have to just take it easy, one step at a time. One step at a time. So ask your questions. And another thing is very important, I also noticed, is that try and let your answers be chronological. Like start from the beginning, don't start at the tail. You already have a mindset of what you want to achieve, so let it just flow, because sometimes for judges who don't record or who still do shorthand, sometimes if it's just scattered, even when they are reading it at the end of the day, it might not really flow. It might not, unless those who are really very, they know what they are doing, and they can be able to pick the answers here and there and fix everything together. So if possible, if it's, let it flow from the beginning, maybe from when everything started, the transaction, and then let it flow. Then ask one question one at a time. Don't rush your question. Don't make the ask five questions at the same time, expecting the witness to give five answers. Don't lodge your questions together. Take your time, one question at a time. Another thing, what I always tell people about trial plan, many people don't understand why they should have a trial plan. You see, have a mindset of what the other party is feeling. No, try to project yourself like, if I'm in this other person's shoe, what will be my mindset? What is in my mind? What am I thinking? What will be my approach? That way, you'll be able to, ask questions that elicit the answers you deserve. So know what the other party will say. Always anticipate your answers. Always anticipate your answers. That way to help you, fine tune your questions to get the desired answers. One other thing many people do, which I've seen many senior lawyers they do, is that they try to, state the kind of the summary of their question. Like the last question they're trying to be, they will ask a question that will be like a summation of everything they've asked you. For example, you may not put it this way, you might just say, so witness, it is true that you do not own that land. For example, if it's a land case, or it is true that you are not the rightful person to issue that order, or it is true that there was a contract between these and they, but there were issues that made the contract not to go as planned. Try and ask a question that kind of represents everything you've been trying to say in that 30 minutes, in that 20 minutes, in that 1 hour. It might be difficult, but try to have a summation. Have a question that has a summation of everything you've been trying to say or you've been trying to ask. So the rules of cross examination is very key. You've done techniques of cross examination. You've done when cross examination is not necessary, and today you're looking at the rules of cross examination, commandments of cross examination, ABC of cross examination. The What I call it, the prerequisite, or not the prerequisite, the I's and T's of cross examination. We've drilled that many things you need to know. That a short bullet point you need to have at the palm of your finger when you're cross examination. Be brief, ask short questions. Do not ask non-leading question. Let your language be simple. Any question I'm asking, you must know the answer. Listen to your witness. Ask your question one at a time. Don't quarrel with your witness. Don't allow the witness to repeat the story of the case. Don't give the witness so much liberty that the witness is even telling you or even asking you questions. Be in charge. Always have in mind what the other party would say or what their intended answer would be. It gives you an understanding of why you should ask your question. Have a trial plan. At the end of the day, ask a question that will summarize the essence of what you elicit from the witness. I just hope you enjoyed today's class. These tips will guide you in, in drafting your cross-examination questions. Go and check the other videos we've done on techniques. There are techniques you need to use, to cross-examine a witness. We have also looked at when cross-examination is not necessary. Check these videos. We have other wonderful videos that are educating, that you need as an advocate, you need as a law student who is coming into the practice, you need as a young lawyer who is trying to, get grasp of this practical knowledge of what you've learned in schools, in the law school. So we are here for you. If you have questions, please drop them in the comment section. It will be attended to. If you're yet to subscribe to the channel, please do hit the subscribe button. Yes, please do hit the subscribe button. Drop your questions as comments. Reach out to us. We'll get back to you. We also mentor law students. We mentor young lawyers who want to, take their place in the legal space, who want to grow more, who want to understand. We have ebooks available, for you. Just reach out to us. We'll have lots of things that will help you become better in whatsoever you have found yourself doing or whatsoever you desire to do, as someone with the law certificate, even as someone who is also a lawyer. Thank you and God bless you. You know what? You can always be the best. Keep pushing. Be resilient. Don't give up. Do take care. Bye.